Good afternoon, Council and Ms. Jorgensen, Judge Greene.
Good afternoon.
Thank you. We are here for day 4 of the hearing, and I am the appointed master in this matter. We are live streaming. Council, would you please place your names on the record?
Good afternoon, Your Honor. My name is Laura Weingarten. I am one of 2 disciplinary co-counsels.
Thank you.
Lynn Helland, I am the other disciplinary counsel.
Thank you.
Good afternoon, Your Honor. Michael Ashcraft, counsel on behalf of Judge Tracy Greene.
Thank you. And good afternoon, Judge Greene.
Good afternoon, Your Honor.
Thank you. And good afternoon, Ms. Jorgensen. We have already stated that there are no preliminary matters that need to be, no additional matters that need to be placed on the record. And so I think at this time, we are ready to call the next witness by disciplinary counsel. That witness is Adam Baker. And also coming into the room, would you explain who that person is, Ms. Weingarten?
Yes, Assistant Attorney General Cassandra Drysdale-Clark. She is representing the Protective Services.
All right, thank you. I am inviting them in from the waiting room at this time. Thank you. Good afternoon. Mr. Adam Baker, you have your microphone on mute. If you would unmute it at this time, please.
Thank you. Good afternoon, Your Honor.
Good afternoon. And good afternoon, Ms. Drysdale-Crown.
Afternoon, Your Honor.
All right, thank you. At this time, disciplinary counsel has called as its first witness today, Mr. Adam Baker. Mr. Baker, I'm going to give you the oath. I'm also going to give you the information from the sequestration order and the order regarding hearing and witness protocol, and make sure that you are aware of those and that you are promising to abide by those orders. Raise your right hand, please. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth, so help you?
Yes, I do.
Thank you. What is your name?
Adam Baker.
All right, thank you, Mr. Baker. With respect to the hearing and witness protocol, witnesses shall certify that they are alone in the room where they testify or identify all individuals present during the examination. Are you alone in the room where you are now?
Yes, I am. I'm in my office.
All right, thank you. No witness shall access or review any documents or materials beyond the relevant trial exhibits, pleadings, or transcripts or police reports during their testimony until the trial is over. No witness shall have a document within reach or sight. And if a witness needs to refer to a document, he may do so only if invited by counsel or approved by the master. Do you understand that, sir?
Yes, I do.
All right, and you don't have any documents there with you for testifying at this time, is that correct?
No.
That is correct?
Oh, sorry. Yes. Yeah. Yes, it is correct.
All right, thank you. Witnesses shall certify under oath that no one has given them information by any means to assist in testifying that counsel and the master cannot observe. Do you certify that?
Yes, I do.
All right, and witnesses shall not have access to cell phones, laptops, smartwatches, or similar devices in the room during their examination other than the device they will use for their virtual testimony. Do you understand that, sir?
Yes, I do. Should I place my phones outside the room?
Yes, or at least far enough away from you that you don't have access to it right now.
Okay, all set.
All right, thank you. With respect to sequestration, that's the second order. This order, sequestration order, will remain in effect until the witnesses are released from it by the master or until the proceedings before the master conclude. To be clear, this means that the order remains in effect even after the witness testifies unless the witness is released by the master. So this is the order. Sequestration includes a prohibition on any witness except while testifying via Zoom during the proceedings from doing any of the following: discussing your testimony in any format or by any means with another witness, viewing the proceedings on any device, listening to the proceedings on any device, or accessing or viewing any information about the proceedings via any social media or news outlets. Any questions regarding that?
No.
Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. A failure to serve the order by any party or a violation of the order by a witness is grounds to exclude a witness or to exclude testimony given by that witness prior to the discovery of the failure or violation. Any questions regarding that, sir?
No.
All right, thank you. At this time, I'm ready for you to proceed, Ms. Weingarten.
Good afternoon, Mr. Baker.
Good afternoon.
I'm the lawyer who subpoenaed you. My name is Laura Weingarten. Can you tell us what your occupation is?
I'm the district manager at Wayne County North Central District for child welfare.
Where is the North Central District located?
We recently moved from the Highland Park address to 8625 Greenfield Road, Detroit, Michigan, 48228.
How long have you been the district manager of that office?
6 years.
Are you familiar with a computer system called MySACWIS?
Yes, I am.
Could you spell that for us?
MISACWIS.
Do those letters stand for anything specifically?
Yes. It's been a while. So Michigan, sorry, I blanked for a second.
Okay, that's okay.
But it's our child welfare system to track data and cases.
For how long has Child Protective Services used MySACWIS?
I believe it came up in 2014.
So at least the 6 years that you've been the district manager?
Yes.
All right. Do you have rules about who is allowed to request a copy of a CPS investigative report?
Yes. There are the CPL and policy dictate who is available to get a copy of a CPS record.
And what does CPL stand for?
Child protection law.
If someone requests a copy of a CPS investigative report and they're entitled to it, how does one go about getting it?
So we have administrative support staff who handles all of our requests. Things have changed too. I'll have to note through, with COVID and our process, and we recently went paperless, but in general, we have a point person that would take any requests for reports. They would then gather those documents and send them over to the redaction unit for redaction. And then they would come back to our local staff to, mail to the individual that has requested the documents. However, if something is of urgent nature and is needed quicker than 14 days, there's occasions where it would be processed locally by a supervisor.
Do you or anyone in your office have our redactors?
Yes, the supervisors can redact, section managers can redact.
Okay, so if a requester is given a document after it's been through redaction, are the documents that they receive signed?
Typically not. Right now, my understanding, especially during this period of COVID, we just give the electronic copies, which don't include a signature typically. but would have the date stamp of the worker disposition and supervisor approval.
Can you explain to us why they're not given a signed copy?
I think a lot of it more recently is the COVID pandemic, and so policy does state that when supervisors approve a report, they should sign the signature page and upload it to the system. But it probably doesn't always happen that it's in there.
So how does one know if there is a final and complete report that the requester is being given?
If something goes through the redaction, and specifically even more so the redaction unit, or if it's done locally by a supervisor, it should be accompanied by an official letter from the redaction unit with a statement that it's protected by child protection law, and you'd be able to see the redactions on that report.
On the bottom of the report, the last page, there's an area for, tell me if this is true. Is there an area for 2 different signatures?
Yes, there is.
Who typically signs those lines?
The worker and supervisor.
And if the report that we have does not have signatures on either line, but they have dates, what does that mean to you?
That means that it's approved.
Does
That
that
the
mean that
worker
that report?
Oh,
I'm sorry, go
the worker dispositioned the case and the supervisor approved the case.
So does that mean that it is an official, complete, final copy?
Yes.
One moment, please.
Certainly.
Did you have anything to do with redacting any of the reports in this case?
Redactions, no.
Do you have any responsibility for the supervising the person who does redact?
Well, we have the redaction unit. So if it is redacted locally, then yes, it would be in the chain of command within our district. So if a supervisor did that locally, yes. But if it went through the redaction unit, no, it's a separate unit.
If we have a report that has date stamps at the bottom of September 18th of 2018 and October 4th of 2018, that was before COVID. Do you agree with that?
Yes, it was.
If it is not signed, but those 2 dates appear at the bottom of the report, can you explain to us why we have unsigned versions even before COVID?
No, I can't explain why there would have been any unsigned copies prior to COVID. I really don't have an answer why. Prior to COVID, we typically give out, when we had our case files, we would give out the true original copy with the signatures included.
If there are not signatures, but there are 2 dates stamped, does that tell you that it's an official and complete copy?
Unless there was an amendment.
Just one moment, Mr. Baker. Ms. Weingarten, would you ask that question again? The very first part of it, first few words were breaking up. Go ahead.
Sure. If the report that we have does not have signatures, but has the 2 dates stamped at the bottom, does that mean it's an official, complete report?
I would say that based just on looking at date stamps, there is possible, and sometimes it happens where there's amendments that happen to reports. So if it was a request that went officially through our redaction unit and was completed, then that should be the completed report.
How would one know whether it went through your redaction unit?
There would be a cover sheet that's associated when it's mailed back to the client, just indicating that it's protected by the child protection law, the information within the report. And it's the official process. So.
Are there other ways for people to get the report other than making an official request? In other words, who's entitled to these reports?
So a report as part of discovery for a child protection proceeding, obviously through the parties in the juvenile court matter, somebody who's identified as a perpetrator could request a copy of the report. It could be if it's a central registry case, police, prosecutor, could be obtain a copy of that report, would get a pot copy.
If that group of people request a report, does it go to the redaction unit first?
If they request it and it's not needed within 14 days, then yes, it would go to the redaction unit. But if it's an urgent request, it would most likely not go to the redaction unit because I think the required time frame is 14 days for redaction.
So is this scenario possible that a parent gets the report in discovery, that it is not signed, but it is dated at the bottom by both the supervisor and the worker, and it's not redacted in any way? Is that possible?
Typically, I believe all documents that go through the juvenile proceeding get redacted. So I would typically not think that they would get an unredacted copy, but I can't say for certain, but I'm pretty sure that they're all redacted.
All right. But the fact that it's not signed, but it is date stamped at the bottom, does that tell you that it's a complete report and final copy of the report?
Again, unless there was a situation that was a cause for amendment or something like that, and if it went through an official process, it would be a official copy.
So the way that you know a report is complete is that at the bottom it has date stamps, even with not without necessarily having signatures. Is that fair to say?
Yes.
Okay, thank you. I have no other questions.
Thank you. Mr. Ashcraft, any questions for this witness?
Yes, I do. Thank you very much, Your Honor. Good afternoon, Mr. Baker.
Good afternoon.
I'm the lawyer that represents Judge Greene in this matter, and I have some questions for you. As district manager for the North Central District for Child Welfare, you are aware of or familiar with the policies for CPS, yes?
Yes.
And you're aware of the guidelines as well?
Yes.
And you're aware of the manuals?
Yes.
CPS policies determine which information is put in the CPS investigative reports, right?
Yes.
And those the forms are called Form DHS 154, is that right?
Yes, that is the investigative summary report.
And CPS policies are contained in the manual that's referred to as the PSM, is that right?
Yes, that's correct.
And what does PSM stand for?
It's the Protective Service Policy Manual.
And the policy manual, Protective Service Policy Manual, is something that's available in-house, so to speak, at CPS.
Yes, it is.
Correct. Okay. And the different workers, including yourself, even as a district manager, you're responsible to follow those things, correct?
Yes, correct.
And does the PSM track, in essence, the Michigan compiled laws and specifically track the Michigan child protection laws that are in place in Michigan?
Does it track or reflect?
Yes, does it reflect?
Yes.
Okay.
Yes, it does reflect that.
Thank you. I'm going to show you a document for just a moment. So if you could kindly bear with me. Your Honor, may I share the screen for a moment?
Yes.
Thank you. And Mr. Baker, are you with me here? You see what's on the screen?
Yes, I did the CPS Investigative General Instructions checklist.
Thank you. And this is just one section of the PSM that I brought up, just so we can confirm through you that this is the PSM. And then over the left side, you'll see all the individual subsections of the PSM are identified, correct?
Correct.
Your Honor, I move for the admission of the PSM, specifically the Children's Protective Services Manual as exhibit number 38.
I
Thank-
have no objection, Your Honor.
It is admitted. Thank you.
Thank you, Judge. Mr. Baker, I have a number of questions with regard to certain protocols and procedures as relates to the workings of the CPS office and specifically through the investigators as overseen by yourself as district manager. CPS policies are things that the workers and your office are required to follow. In other words, they're not something that is simply a guideline and discretion attaches that allows a worker not to follow a specific guideline or a policy standard, correct?
Correct.
How much autonomy does an individual worker have with regard to doing their work?
So obviously, staff go in the field. We encourage that staff always go in the field in pairs. But the interview process, staff are usually completing. The supervisors not typically in the field. There may be some situations where they're required to, but there's some autonomy for the field work. When you're talking about decision making, that is required to have conferences with supervision.
What kinds of things are required to be reviewed then by a supervisor?
The supervisors basically review the case in its entirety and make sure that there's policy compliance prior to approval.
So in essence, is it not only double checking the field work, but also making sure that the different standards as contained in the manuals, such as the PSM, have been followed?
Yes.
During an investigation of child abuse and neglect, CPS is required to engage relatives and other individuals identified as witnesses or people having information relevant to the investigation. Isn't that right?
Correct.
How does the worker go about determining which of the relatives or witnesses will be interviewed?
So typically it's the parents who would identify relatives, but we strongly encourage as many collateral contacts as you can make on a case.
So if a parent or a relative tells a worker that there are witnesses who refute statements of children alleging abuse or neglect, the worker would be duty bound to interview those witnesses, right?
Yes.
What is the policy with regard to returning phone calls or emails concerning an investigation of child abuse or neglect?
Typically, I'm trying to think if there's an actual protocol within the manual, but we were encouraged within 48 hours return calls.
Okay. I'd like to talk for a minute about reports. Who's required to approve the final CPS investigative report?
The supervisor.
And that report is sometimes referred to as number 154, is that right?
Yep, an investigative summary.
And how is that approval reflected?
It's typically with the date stamp at the bottom and a company signature.
And you explained already to us in terms of why there might be signatures on some reports and not signatures on the other. But how is it that you are able to confirm internally that a supervisor has in fact, in essence, signed off on an investigative report?
The case will be closed in the system or opened if it's a court case or if there's services provided to the family.
So if something has been closed in the system from years ago, would it be unusual for it to be opened up years later?
Yes, that would be unusual to open something that's been closed for some time.
And as far as when these reports are released to those individuals who may be entitled to have them, of course, after redaction, as you've talked about already, how is it that that individual that receives a report is assured that it has been approved, reviewed and approved by the supervisor?
How is a person, could you repeat the question? How is a person that, oh, go ahead.
Yes, sir. When a report has been released to an individual who is entitled to have a copy of the report, of course, after redaction, as you just explained to us, how is it that the recipient is to know that the report has in fact been reviewed and approved by a supervisor?
So that would either, if it was less than 14 days, it would be coming directly from the supervisor to that individual. Or if it was through the redaction unit, would have the associated documents with the redactions and the cover letter indicating, that the information is protected by child protection law.
Are you saying, Mr. Baker, that sometimes reports are released to individuals that are entitled to have a copy that have not been redacted and include information that would otherwise be redacted?
They should not be released.
Okay. So if a report goes out, even if it's within that, I believe you used earlier, a rush kind of time frame within 14 days, having not cleared the redaction unit, the report would still be approved by the supervisor, and the whatever needs to be redacted has been redacted by that time.
Yes, it would, unless there's some type of amendment to the case.
You talked about amendments a few minutes ago. When you say an amendment, what do you mean by an amendment in the case?
An amendment just could be additional work being completed.
Is additional work, strike that. But let me ask you, as far as the closing of the file, you've indicated that that occurs and it would be unusual for it to be reopened years later. Would an amendment years after the fact of the file being closed be unusual?
Yeah, I believe an amendment even years later, usually amendments or something being reopened would typically take place pretty quickly.
Okay. And likewise, when you say amendments, you're talking about things like revisions.
Yes.
Understood. Would it also be unusual for signed copies of the CPS investigative reports, as well as unsigned copies of those reports, being released to people who would be entitled to receive a copy?
Would it be sorry, could you repeat that? Unusual, did you say?
Yes, sir. Would it be unusual for that to occur?
For a person to receive both copies, the unsigned and the date stamp?
Yes.
If the request is specifically for signed copies and we pull the case files, then I don't think it would be, it just depends on the situation, I would think. Because somebody could request a copy and then they could request if they wanted the signature copies and they were there, they could get a copy of those.
Understood. But there shouldn't be different iterations of the CPS investigative report after it has been approved by the supervisor and released to someone entitled to receive it, right?
Right.
Okay. Now, once the supervisor reviews it, it is uploaded into, and I believe we pronounce it MySAQUIS.
Yep.
All right. And then does it
Yes.
stay? I'm sorry, I spoke over you.
No, I just said yes.
And does it stay in MySAQUIS the entire time? Meaning that once it's in MySAQUIS and the file is eventually finalized and closed, does it remain in that system?
Yes, it does.
And is an investigator, a worker, or anyone for that matter at CPS able to get back into a closed file in MySAQUIS, and revise or edit or amend?
Not if the case is closed. No, they cannot get in there to do any kind of changes.
Okay.
Could
So it
you
would be-
please repeat your answer? You said no if the case isn't closed or is closed. I didn't hear that.
If the case is closed, they can't or I should say, if the case is closed or the social work contacts are finalized. I believe I know for sure if the case is closed, they can't go and modify social work contacts or anything like that. But also within an open case, if the supervisor finalizes a social work contact, I believe it can't be modified.
Thank you.
Thank you, Judge. And Mr. Baker, you told Ms. Weingarten about the dates at the bottom of the investigative reports. And is that reflective of when a case is finalized?
Yes, it is.
So revisions, amendments after those dates, or that date at the bottom of the CPS report, those are things that would be unusual, as you talked about.
In what matter?
Well, in any matter, I'm trying to establish when something becomes final. The final version is in the MySAQUIS system, and the file is closed. Does that correlate to the dates at the bottom of the CPS investigative reports?
Yes.
Okay, understood. Thank you. How many separate reports for a single investigation are uploaded into MySAQUIS?
Typically one. If you have one case, it would be one investigative report.
And is there a way or a mechanism for there to be, in fact, more than one investigative report on the same case uploaded into MySAQUIS?
It would still be the same report, but if there was amendment or reopening, it would still be the same report, but maybe look a little bit different, if that makes sense.
Could you help me understand when you say look a little bit different? What does that mean?
I mean, if there was additional things in the report, then it would, reflect an amendment to the case.
I see. So if there is more than one report in MySAQUIS, how does the department confirm which version is in fact the final report?
If you do an official request, what is finalized on the system. So if we generate it now, we'll generate as the finalized copy.
So if someone that is entitled to receive a copy of the report asks for it through formal channels, and when I say formal channels, I mean through your offices and your work, what they receive, then they should understand that in fact is the final report.
Yes.
How does the department ensure that the report that is disseminated or supplied to someone outside of the department is being provided to someone who's authorized by law to receive a copy?
That individual obviously would have the credentials or the ID if it's a specific individual who's named on the report. They would have an ID to verify that they are in fact the person.
I would think that the department sometimes receives bias complaints regarding workers and their immediate supervisors. Is that right?
Yes, we could receive that information.
And how is there an agency protocol or a department protocol that deals with investigating bias complaints?
I think it's more of a situation where the managers would look into the situation and make a determination.
So if a bias complaint.
One moment, Mr. Ashcraft. I believe I know what you're talking about as far as a bias report, but could you break it down just so that I'm sure?
Yes, Judge. If someone involved in an investigation complains that they believe that they've been identified or being questioned or being part of the investigation as a result of some bias, that they would report that to the department and in essence complain about that.
Thank you.
You're welcome. And Mr. Baker, you indicated that yes, that's accurate. My question and follow-up is whether there is some sort of a protocol, manual, or rule, guideline, something that we've talked about already. For example, something within the PSM that addresses how these bias complaints are handled.
Yeah, it could range on a different range of activities. You could reassign something for, you know, a different investigator to take a look at.
So sometimes bias complaints are addressed by having a new investigative worker put on a matter.
Yes,
How about a manager? Are managers replaced sometimes as a result?
it could be assigned to a different team.
And when you, well, who determines whether an investigation is even warranted in the first place? Is that the manager?
Yes, the manager, myself, sometimes the county leadership.
And would you or the manager then have discretion to figure out or determine how to go about conducting the investigation of bias?
Yes.
And is there a certain time within which the bias investigation has to be conducted and completed?
Offhand, I'm not. Are you talking about like a labor relation issue?
No, sir. I'm talking about internal policy there. When you receive that bias complaint and it rises to your attention or a manager's attention, and you exercise your discretion in investigating it, my question is specific as to whether or not there's a time period within which you have to resolve that bias complaint.
We typically try to resolve those as soon as possible when we become aware of them.
Okay. And we spoke earlier about returning phone calls, emails, and the like, specifically with regard to bias complaints and people calling in or sending emails about bias complaints. The same rules apply, right? And that is, policy is they have to be returned, all of them.
Yes.
And would the CPS report reflect any unsuccessful attempts by the worker or the investigator to return phone calls or respond to emails, et cetera?
It should. We encourage staff to put all social work contacts into the system.
So
I'm sorry,
CPS,
there was some feedback over that answer. Could I get a repeat of that?
Yes, it should reflect all of their social work contacts and efforts. We encourage staff to enter all social work contacts into the case.
and you introduced a little phrase there that I think I understand, but I want to clarify. You said social work contacts. Does that mean, in essence, the work and the contacts that are being made during the course of the investigation of a matter?
Yes.
Okay, I wanted to make sure there wasn't a term of art ascribed to that phrase.
No, and I can expand just within the 154, the investigative summary, it's basically filled with social work contacts, different dates, different activities.
I see. Understood. That's helpful. Thank you. So CPS personnel and management would never ignore or fail to return phone calls or emails, correct?
No,
That is
ideally,
correct?
no.
I'm sorry, it wasn't an artfully phrased
Oh,
question.
sorry.
No, don't be sorry. The answer to my question is that's correct?
Can you repeat it again?
Yes. So CPS personnel, specifically managers and you, for example, would never ignore or fail to return phone calls or emails, correct?
Ideally, no. That nobody would miss returning calls and emails and things of that nature.
Thank you, because that in fact would be a violation of the rules and the policies, specifically in the PSM.
I think he's looking for an answer.
Oh,
Yeah, I'm sorry. Yeah, I see you nodding your head, but we have to have an oral.
oh yes.
All right, thank you, sir. But nor would a district manager ignore a complainant's email requesting clarification about the disposition of an investigation of allegations of a confidentiality breach by CPS, right?
No, but that could be, those kind of emails, communications could be delegated to a manager or a supervisor to follow up with.
But ultimately, they would be followed up with because that's the policy requirement.
Yes.
And how is the complainant of the bias investigation notified of the findings of your internal investigation?
Well, if it's a formal complaint in writing, we would respond to that. Sometimes it might be verbally over the phone.
Is there a protocol or a policy in place that requires it to be documented in some particular way?
Yeah, ideally it would be documented in writing.
And would it be documented as part of the, and I'll use your phrase there, the Form 154?
No, that would not be included in the 154.
Understood. And so if someone then who's entitled to receive a copy of the CPS investigative report asks for the report, then the report will be provided subject to redaction, but they will not necessarily receive a copy of this other report that talks about confirmation of completion of the investigation of a bias complaint.
I think if it's in writing, yes, we will respond to that in writing. But if it's something that's handled over the phone, we often talk through those things with clients.
So that it's not necessarily reduced to writing?
Yes, and there may be some situations like that.
Okay. But it has to be recorded somehow in your internal files, whether it's in the 154, the CPS investigative report, or some other document in your system.
Yeah, if it's a formal complaint of bias or something, it would be, we would have record of that and a response.
Thank you. I want to go on to a different area now. One of the most critical parts of the CPS investigator's job is the placement of children who have been removed from their homes, correct?
Yes.
And before foster care placement with strangers, Michigan law, as well as NDHHS policy, require that blood relatives be considered for placement, right?
Correct.
And first in priority, based on the law and the policy, is consideration of non-custodial parents, correct?
Yes, correct.
And then in terms of the order, then blood relatives within a certain degree of blood. Yes?
Yes.
And then finally, foster or stranger care workers in that category, right?
Correct.
So non-custodial parents are given preference over all other relatives unless they have been disqualified for consideration. Is that right?
Yes, that's right.
Thank you. I'd like to ask you some questions about family team meetings. These are sometimes referred to in your department as FTMs. Is that right?
FTMs or TDMs now.
Oh, TDMs. And TDM stands for?
Team decision making.
Thank you. I'll use FTM because that's the one I'm familiar with, okay? FTM and another critical part of the CPS investigator's job is to arrange, coordinate, and participate in the FTMs, correct?
Correct.
And can you just give a little description here about the objectives and the purpose of an FTM? I mean, what is it?
FTM is whenever you have a critical point in a case. So if you have a considered removal, an emergency removal, separation of children from parents, or if you're talking on the foster care side, a change of placement or moving from supervised to unsupervised visits or reunification, those are some key points to have TDMs, and FTMs are also done quarterly in foster care cases and prior to closure and ongoing PS cases that are where services are being provided. But it's basically to bring family, friends, support people to the table to talk through any issues and to sort out any safety concerns and establish a plan for the case going forward.
So it is essentially, it essentially consists of fact finding.
Yes.
As well as problem solving.
Well,
right.
Some of the facts of the case, if it's an emergency or considered removal, the facts will be presented. But as it being an investigative tool, that is not the intent of a FTM, but it's to bring people to the table for case planning. Obviously, if something comes out that is unknown, it might be considered for the part of the investigation.
So it would factor in, the FTM would factor into problem solving in later stages then?
Yes.
Okay, I think I understand. And then it also, it's used for decision making as well.
Correct.
So for example, whether a child would be removed from the parent's home
Yes,
and where and with whom that child might be placed.
correct.
And at the FTM, is CPS expected to determine what, if any, services the family needs?
Yes, if it's if it's a case that's a non-egregious case, so it's not mandated by a petition by the child protection law, then we would talk about services for the family and what can be put in place.
You said a couple things there that I'd like to ask you to clarify: non-egregious and mandatory petition. Could you explain those two things, please?
Yep, like sexual abuse, severe physical injury. If you look at some of the criminal codes, offhand, a child abuse 1, 2, I think 3 and 4 might be part of that mandatory petition. Exposure to methamphetamines. So some of those situations are the mandatory petition.
So there are situations that require filing of petitions as a mandatory situation.
Correct.
Thank you. Going back to the FTMs for a moment, CPS also has to determine what the family's strengths and weaknesses are.
Yes.
Correct? So who is it that participates in the FTM?
The worker, supervisor, parents, and hopefully support people. Now that we're under the TDM model, we also try to bring in community partners that might specialize in a special area that would help the family. And just so I'm clear, TDM, when did that come into place? It's more recent from, we've been doing a pilot, the TDM pilot. I can't remember the date of the start, but it's over a year. So yeah, probably maybe the TDMs began in the first model December maybe of 19, but I can't be sure. Okay, thank you. So are professionals present during the FTMs? Sometimes. I mean, we've had law enforcement at FTMs, we've had counselors, we've had all types of different support peoples for families. And would that also include an FTM coordinator? Yes, if there was a facilitator. And does the FTM coordinator essentially serve a role as a neutral observer? Yes. Is there a designated person who is supposed to be the neutral observer, this coordinator? Yes, there is a designated individual. However, I'm kind of thinking in two different models, because if we have FTMs now, they're sometimes facilitated directly by the worker, the supervisor, or another staff that's available. The TDM model has strictly facilitators. Okay, so that's the new system, so to speak. Yeah, we did have facilitators too that would facilitate previously. All right. Is before you moved into the TDM model, and I'll just use that. I realize that may not be your choice of words, but before you moved into the TDM model, were there designated people, for example, a pool of FTM coordinators at CPS? Yeah, there wasn't, they weren't called FTM coordinators, but we had some people that did facilitation. Did they have a title? If I'm not using the right phrase, I'd like to know. It's going to be a challenge for me to remember it. It's okay. I think they were my team specialists at the time, maybe. Okay. They may have been. All right, thank you. One of the goals in the FTMs is to involve and engage the relatives as much as possible, right? Yes. And that would include grandparents? Yes.
And the reason for that is that the grandparents oftentimes have a great deal of insight into family dynamics, problems, and the like, correct?
Correct.
And involving the grandparents is usually in the children's best interests.
Yes.
What about non-custodial parents who have not been involved with their children? Are they notified or included in the FTMs?
They should be, yes.
And CPS investigators encounter that sort of scenario commonly, do they not?
Yes.
And it's part of CPS's policy to verify any custody or parenting time orders regarding the children, right?
Correct.
And that's an actual requirement, is it not?
Yes.
And once obtained, those orders, if they exist, would be uploaded into my SOC list, correct?
Yes. Ideally, yes.
And when you say ideally, what does that mean?
Well, I mean, there's might be some, if it's an order, if it's something they're looking at off of a screenshot, which I guess is not an official order, but if they're making reference to what they observed on court view, maybe not specific to orders, but just regarding a friend of the court case, they may document it in the social work context. But if they have an order, it should be uploaded.
I see. And CPS is also required to notify the friend of the court if there is an open CPS investigation, right?
Correct.
And CPS is required by law to identify any friend of the court cases as part of its investigation.
Yes.
And that's to ensure that the department's decisions or actions are not in conflict with any existing court orders, right?
Correct.
And so that CPS can't take anybody's word for what custody and parenting time arrangements actually are. They need to be verified, essentially.
Yes.
Thank you. And it would be against CPS's policy to place children in a home with a parent for whom the family court had ordered to have only supervised parenting time, right?
It would be against the friend of the court order, correct?
Let me ask the question again. It would be against CPS's policy to place children in a home with a parent for whom the family court system had already entered an order that parents only have supervised parenting time, correct?
Yeah, but those things can be discussed if a petition's filed in court.
So the issues can be addressed, but still in the court system.
Yes.
But it would be contrary to CPS policy to place a child in the home of a parent that is subject to a family court order that says that parent could only have supervised parenting time.
It would be conflicting to the order. Yes.
And then, of course, that would be contrary to policy, would it not?
So if there was a voluntary safety plan and maybe a parent consented to that, then, and there was we're filing a petition, I could see an arrangement possibly happening, but I think it's probably safe to say that it's conflicting with a court order. So unless we file a petition to get the court to address that specific issue, it would be conflicting.
Okay. And just to make sure that I understand your answer, that means that it would be contrary to CPS policy to place a child with a parent who is subject to a family court order that only allows him or her supervised parenting time with that child, correct?
I would have, I'm having a bit of a difficult time because I would have to go look at the policy to see how it specifically addresses us. I can't say offhand, but my first assumption is that anytime you have a court order for custody, just like we can't separate that arrangement without filing a petition.
All right. So maybe I can ask it this way and I'll better understand your answer. So if you just bear with me for a moment. CPS would not have the discretion, or exercising discretion would be contrary to policy if CPS placed a child with a parent in a situation where the parent had a family court order in place that limited that parent to supervised parenting time with that child only, because that would be in conflict with that order. So in order to do that, you would have to file a petition and in essence, get court input and authority to do so.
Yeah, we can't just, we don't have the discretion just to separate kids from their parents. So either there's a voluntary agreement by the custodial parent that allows that to happen, or we file a petition and take action in court and address the issue in juvenile court.
All right. And so CPS doesn't have discretion or authority to contravene or disregard an existing order of a family court when it comes to placement of a child with a parent, correct?
Correct, but until that petition's filed, you know, the custodial parent can decide as well, you know, if they're going to allow that safety plan to take place.
I see. So if the custodial parent says, well, that's okay while the petition is pending, then you can envision a situation where that would occur.
Yes.
Okay, I understand. Thank you very much. And are there rules or protocols for FTMs as well?
Yes.
And for example, some of those rules and protocols would deal with sidebar discussions, correct?
Yeah, you mean sidebar, could you be more specific?
Well, are you familiar with, I'm sorry, I spoke over you.
No, I was just asking, could you be more specific? Are you talking between a facilitator and an individual, or, I mean, so with the FTM format is an open format discussion. That doesn't mean that the meetings don't stop sometimes to have a pause and, you know, parties discuss things on their own, or, you know, a supervisor worker may discuss something, or a facilitator may discuss something with a family. You know, so it just depends.
Okay, but sidebar discussions between or among participants, that's prohibited, correct?
It would be very disruptive to the process, I think.
Well, so there's no policy that says you cannot or you should not do that?
I would have to go look at the TDM protocol specifically to refresh my memory. But I would think that wouldn't be encouraged.
All right. So for example, whispering between participants, that's something that would not be allowed.
Yeah, I mean, it depends on the situation with, if you have a worker or a supervisor. I mean, in what context, I don't know. If it's something, you know, but generally, no, it shouldn't be a meeting of whispers, right?
Right. It's the same thing with regard to passing of notes between certain participants.
Yes, I would think there's some issues probably with feeling respected.
And of course, in today's technological world, same thing with texting between some of the participants.
Yes, I believe that they do want phones off or on vibrate during the meetings.
Would you go ahead and say that again? I believe that they do want or do not want. I couldn't hear.
I believe they do request that phones are off or on vibrate during the meeting.
Thank you.
Thank you, Judge. And Mr. Baker, the reasons for this is that you want to avoid distractions at the FTMs, obviously,
Yes,
and also to avoid the appearance of collusion or bias, right?
yes,
And ultimately, that's the reason that the FTM coordinator, and I forget what the actual title that you told me what that FTM coordinator is, but ultimately that's the role of the FTM coordinator, is to be there as a neutral party to make sure these things don't occur.
correct.
And part of the process and the protocol is that everyone involved agrees in advance of the meeting that they're going to follow the rules.
Yes,
So the family team meeting is where the decision is made on how to proceed in a CPS case, right?
correct.
So what are the possible outcomes of an FTM?
Petition or maintain in home with some community services. Usually those two. I mean, if you're talking about considered removal, you may have a preponderance of evidence, but you just are determining if it is something that can be managed in the home or if it needs to go to court.
And an FTM is always convened when removal from the custodial parents or legal caregiver's home and foster care or relative placement is being contemplated, right?
Yes,
And when a petition to get to the court or to get the court involved is anticipated.
yes,
Okay. And one of those would be petitions to terminate parental rights.
correct.
The removal and placement decisions are never made before the before the FTM is ever conducted, is it?
No, the goal of the TDM is to, unless it's an egregious act or a mandatory petition, then it would be a agreed upon outcome. As long as it's in the end, if PS does have the evidence that supports safety concerns, there's some times where it can't be avoided that a petition needs to be filed.
And I think you used an acronym. Did you say PS?
Yeah, sorry, protective services.
Thank you. Just want to make sure I know what we're talking about here.
Yeah.
Now, in the event that were to occur, meaning an egregious situation requiring immediate action, that is something, though, that would be documented in the file.
Yes,
And would it be documented in the 154 CPS report?
yes,
Regarding a pending CPS child abuse and neglect investigation, they are required to be completed within 30 days unless extended, correct?
correct.
But in order to be extended, a caseworker has to document the reasons for the extension and submit an actual request prior to the end of that 30-day period, right?
Yes, correct.
And there's, I think, something called standard of promptness, SOP. Is that what applies to that?
Yes,
Extensions are not to be approved solely for the purpose of meeting the SOP, though, right?
correct.
Approval can only occur under 4 specified limited circumstances, correct?
Yes,
The first is obtaining medical records or a secondary medical opinion to verify an injury or medical condition, right?
correct.
The second is to obtain mental health evaluations, reports, or records necessary to reach an accurate case disposition, right?
Correct.
The third is to coordinate interviews with law enforcement necessary to reach an accurate case disposition, right?
Correct.
And the fourth one is coordinating interviews with other states or counties necessary to complete a thorough investigation.
Correct.
Thank you. Extensions which do not fall under these circumstances may be allowed, but only if reviewed and approved by Children's Services Agency, executive director, or a designee, correct?
Correct.
Before the requesting the CSA executive director's approval, though, caseworkers must complete and document all requirements detailed in the investigative requirements, right?
Yes, the investigative checklist, right? Sorry,
Right.
just for clarification.
Right. And the CSA executive director or their designee's approval of an extension must be documented in the supervisor approval section in my SACWIS, correct?
Correct.
As well as in the social work context of the 154, the CPS investigative report, correct?
Correct.
Thank you. And the approval must be scanned and uploaded to the documents section, right?
Yes.
And once an investigation is completed, the suspected perpetrators of abuse or neglect must be told the outcome or the disposition of the investigation.
Correct.
CPS would not complete an investigation and not notify the suspected perpetrators, right?
They would, could you reword that, or not reword it, but restate it?
Yes, sir. The CPS would not complete its investigation, in other words, finalize its investigation, and not notify the suspected perpetrators of the conclusion, correct?
Right. They're supposed to notify the parties of the disposition.
And if the investigation is a reinvestigation by a new worker who may have replaced a previous worker after, for example, a bias complaint, the new worker would at the very least notify the alleged perpetrators that the reinvestigation had been completed, right?
Correct.
And these notifications would be documented in the CPS report, the 154.
Correct.
Thank you. I'd like to move on now to another topic for you, specifically dealing with petitions. Generally, who prepares the petitions that are filed in the juvenile court?
So our staff start the petition, and then it goes for a supervisor review. And unless it's not an emergency situation, the second line manager would review it. And then the AAG's office reviews it after that.
I see. And so when you say the AG's office, they in essence have oversight for Wayne County on these matters.
Correct.
The petition notifies the parents or the respondents and the court of what the allegations that the department intends to prove, right?
Correct.
So the department prosecutes only credible allegations of abuse or neglect in court, at least, right?
Yes, those supported by our dispositions that are a preponderance of evidence.
And those allegations that can be proved by a preponderance of the evidence, is that the standard?
Yes.
And CPS pursues all such allegations, right?
Correct.
Now, do cases go to trial sometimes?
Yes, they do.
And if they go to trial, before they go to trial, are petitions sometimes amended?
Yes, petitions are amended.
And for example, allegations or charges, for want of a better word, those things are sometimes removed entirely from a petition.
They could be.
But the department would not maintain allegations of serious abuse by a parent, for example, like sexual abuse, but make no mention of those allegations at trial, correct?
Could you restate the question one more time?
Yes, you indicated that sometimes they're amended before they would go to trial. The petition would be amended before the matter goes to trial, but the department would never maintain allegations of serious abuse, something like sexual abuse, in the petition, but then not bring it to the court's attention during the course of the trial, correct?
Objection, Your Honor.
What's the objection?
It's the Attorney General who brings allegations before the court, not CPS.
Response, Mr. Ashcraft?
Your Honor, I believe that the allegations of CPS are what's being, in essence, prosecuted by the Attorney General's office on behalf of Wayne County. So Mr. Baker would understand as manager exactly how that happens.
The objection is sustained. You may reword your question if you'd like.
Thank you, Judge. If allegations of sexual abuse are maintained in a petition, the department then intends to prosecute those allegations, correct?
Yes.
And knowing whether to see termination of parental rights is an important part of a CPS worker's job, right?
Yes.
So a CPS worker would know that termination of parental rights should only be sought in the most severe cases of child abuse or neglect, right?
Yes, those cases that require termination.
And that would include cases where there's been severe physical injury.
Yes,
And severe physical injury, in fact, is defined by CPS protocol or the guidelines, is it not?
yes, it is.
And severe physical injury is an injury to a child that requires medical treatment or hospitalization and that seriously impairs the child's health or physical well-being, right?
Correct.
And CPS might file a petition to terminate parental rights for other serious safety concerns, like a parent's history of violence, especially towards a child, correct?
Correct.
Or for a parent's refusal to seek and maintain treatment for emotional or mental health concerns or problems that have affected that parent.
Yes.
And some common bases for the department seeking termination of parental rights is severe physical abuse and neglect,
Yes.
including failure to address untreated mental health issues that affect parenting ability specifically, right?
Yes. But we always, I shouldn't say always, but there are situations if we're, it's hard to pull out pieces of this because we're talking about different maltreatments. So if you're saying mental health issues, we do have a lot of clients that have mental health issues and can't care for kids, and we're required to provide services in accordance with the American Disabilities Act. So, I mean, there are situations where we do try to preserve kids with family or their parents.
All right. Yeah, but
One moment. I did not hear the last part of what you're saying, Mr. Baker. It was breaking up. So would you say that again, please?
So I was having a hard time, Your Honor, following the different maltreatments and kind of, because they were coming together. But if we're talking about mental health, there's many situations where a parent has significant mental health issues, and we still try to provide services and for reunification with that parent. So it isn't always just a straight termination. We're required to comply with the American with Disability Acts for those type of situations. So I don't know if that answered the question.
Well, I heard that answer. I didn't hear all of the first time you answered. Thank you. Go ahead, Mr. Ashcraft.
thank you, Judge. Just so that I understand, Mr. Baker, it would then be against CPS's policy to place children in the care and home of someone alleged to suffer from untreated mental health diagnoses without first investigating those allegations, correct?
We would do an assessment if those concerns were brought up, yes.
And that is the responsibility of CPS to make that safety risk assessment.
To do the home assessment.
When you say do the home assessment, it includes specifically investigating an allegation or information about a parent who will become or would become custodial parent who's dealing with an untreated mental health diagnosis.
Yes, we would complete the assessment.
Thank you. And because the entire goal of CPS is to keep vulnerable children safe and healthy.
Correct.
Another basis for seeking termination of parental rights is multiple previous CPS interventions where the parent has not benefited from previous services provided, correct?
Yeah, just for elaboration, are you talking about prior termination of parental rights?
Not necessarily prior termination of parental rights, but yes, let's start with that, prior termination of parental rights.
And sorry, I forgot the first part of the question.
Yes. Another reason or a basis for seeking termination of parental rights is previous termination of parental rights.
Right, and the issues that existed then continue to be an issue.
Right, and then it's a little bit more than that, is it not? Meaning that another basis for seeking termination of parental rights is multiple previous CPS interventions, where CPS's intervention for the family or with the family and essentially did not benefit the family. Problems still continued.
You know, that's kind of subjective, because there are families that you know, have quite a few involvements with PS, and that would, just because they had you know, a couple multiple substantiations, wouldn't necessarily mean that we would file a petition to terminate their rights. And there might be, so it's situational, if I could respond that way,
And is
depending
this
on the factors of the case.
understood? And would this be a situation that would be left to the subjective assessment of the caseworker and the supervisor or manager?
Yes, caseworker and supervisor. And then if they're filing a petition, obviously the second line manager.
Thank you. And another basis for seeking termination of parental rights would be where a parent has an extensive violent criminal history, right?
Correct.
And another common basis for the department seeking termination of parental rights is the abandonment for more than 90 days. Is that right?
Yes.
In fact, abandonment or desertion of children for more than 90 days is a ground for termination of parental rights under specific state law, correct?
Correct.
So it would violate CPS's policy to place children with a parent who has deserted her children for a minimum of 3 months, correct?
Yeah, it depends on the context, I would say. And sorry, maybe because I'm using some of the prior questioning in my thought process. You know, can you reword it one more time? Or not reword it, but just restate it, sorry.
Sure. It would violate CPS's policy to place children with a parent who deserted his or her children for a minimum of 3 months, correct?
If we're talking strictly about an abandonment case, where the parents left the kids with a relative and has never seen them again, I would say yes, that would meet the criteria.
Thank you. Abandonment of young children is one of those situations of abuse for which the child protection laws in Michigan mandate the filing of a petition to terminate parental rights, right?
Correct.
A caseworker must submit a petition when it is determined that there is a preponderance of evidence that a parent, guardian, custodian, or a person who is 18 years of age or older and who resides for any length of time in the child's home has abused a child or a sibling of the child, and the abuse includes one or more of the following, and that is abandonment, correct?
Correct.
And my SACWIS refers to abandonment of a young child as an egregious act, does it not?
Correct.
So there's no worker or supervisor discretion under the child protection laws or even CPS policy concerning whether the filing of a mandatory petition is warranted, right?
Correct.
And although the department may, after filing a mandatory petition, decide to amend the petition or withdraw the request for termination of parental rights, the petition itself still must be filed under the law, correct?
Correct.
And the child protection law requires that all department employees involved in investigating child abuse and neglect cases shall be trained in the legal duties pertaining to their work, right?
Yes.
Your Honor, at this time, I'm going to object to this line of questioning.
What's the objection?
The objection is that Mr. Ashcraft seems to be putting CPS on trial for their decisions in this case and other cases. And that's not why we're here.
So your objection is to relevance?
Yes.
Mr. Ashcraft, response?
Thank you, Judge. I'm not sure how it can be anything less than relevant. Mr. Baker is the manager, the district manager for the North Central District of Child Welfare. And I'm asking with regard to the policies, procedures, and guidelines that CPS has to follow during their investigation. And we know that at the heart of this case, we're dealing with CPS investigations. And Ms. Weingarten, during her direct examination, asked all kinds of questions that dealt specifically with the policies, procedures, and guidelines, and even gave Mr. Baker multiple hypotheticals to respond to. Things that began with if, and then the question concluded with then, and asked Mr. Baker to confirm whether that was right or whether it wasn't right, and then to explain it. I'm doing nothing different than that specific thing.
Anything further, Mr.
Yes,
Ms.
Your Honor.
Weingarten?
Yes, my questions to Mr. Baker had to do with why a report might not be signed or why it's dated rather than signed. Those were the hypothetical questions I was asking him, not about things that had nothing to do with these specific facts of our case. I think Mr. Ashcraft has lost sight of the fact that this case involves Tracy Greene and not CPS as a defendant.
Any final response before I rule on the objection?
Yes, Your Honor, I do have a response, and that is, this is not a closing argument. And we do know that by Your Honor's earlier ruling, a CPS report may come in to evidence here for a very limited purpose and under a very limited ruling. And these are things that I would like to be able to use and establish through this witness who's in a position to talk about policies, procedures, guidelines, mandatory rules, etc., and use that for purposes of dealing with argument and all kinds of other things in the event additional witnesses come in.
All right, thank you. I'm going to sustain the objection, but Mr. Ashcraft, if you'd like to make a separate record, then we can go ahead with that. I would also suggest, though, if we are going to do that, that we take a 10-minute break first, and because we've been going for about an hour and a half.
Okay, Judge,
All right.
that would be great if we could take a break.
All right, when we come back, you can let me know if you want to make a separate record and continue down that lane. All right, let's take a break right now. Mr. Baker, I don't know if you are going to go somewhere or stay there, but you may put your microphone on mute and also your video, but we'll be back within 10 minutes to get started up again. And you're still under oath. Thank you.
Thank you, Your Honor.
And Your Honor, if you could kindly move Judge Greene and myself into the breakout room that we talked about.
Certainly, I will do that.
Thank you, Judge.
I believe we're all back. Mr. Ashcraft, what is your decision with respect to a separate record?
Judge, I'll just move on at this point.
All right, thank you, Mr. Ashcraft. Let's continue.
Thank you, Judge. Mr. Baker, I just have a few more questions for you. And specifically, I want to talk about some of the things that you already spoke about. We were talking about the finalization of the 154 and the CPS investigative report in the system. Isn't it right that no part of the CPS investigative report can be modified, revised, or amended after it is finalized and closed in the system, unless the case itself is later reopened?
Objection asked and answered.
Objections overruled. You may ask the question. Please answer.
Thank you, Judge.
Yes, so an amendment can take place through a reopening.
But other than that, no part of a 154 CPS investigative report can be modified, revised, or amended after it is finalized and closed in the system, correct?
Yes, it cannot be modified unless it's reopened for amendment or something like that. And even those, I believe those social work contacts, once they're authorized, I'm not sure, but I'm pretty sure that once they're finalized, they don't go back to review status, but I could be wrong on that. I'd have to double check.
Well, I think that you said that unless the case is open for amendment. Is that what you said?
Yes.
Well, when you say open for amendment, you're not talking about opened years later for purposes of amending any part of the report. You're talking about opening because there's new developments in the case, correct?
Yes, reopening would be, and I guess, so I mean, I'm kind of thrown off by the years later question. So maybe if we could break it down a little bit to specifically.
Sure, I'm happy to ask you other questions about this. You testified that once, right that, you testified, Mr. Baker, that the report cannot be modified, revised, or amended after it's finalized or closed in the system.
Right.
And that's accurate, correct?
Correct.
And my clarification question is, no part of the report can be modified, revised, or amended after it's finalized and closed in the system, correct?
Yes, unless it's reopened.
Okay, and if it's reopened, it can be reopened at any time later on, but if it's reopened for the purposes of continuing an investigation because of something new that has occurred in the matter.
Yes, usually that would be for additional work.
Right. It's not reopened because the CPS investigator, supervisor, or manager wants to go back in and revise, amend, or modify something that was previously in the 154, correct?
No, the supervisor can't discretionary open a case by themselves.
So is the answer to my question that I'm correct?
Can you state it one more time? I just want to make sure I'm.
Yes. In other words, a CPS worker, investigator, manager, whomever at the department cannot go back into a finalized and closed CPS investigative report 154 and revise, modify, or amend the information contained in it. That's not why or an acceptable reason to reopen the file, correct?
Just to do a modification?
Yes.
No, usually it's for additional work needs to be complete.
Well, when you say usually,
It's for additional work.
It's because
Sorry.
additional work is necessary on the case.
Correct.
After it is closed, but it's about the case. It's not about revising, amending, or modifying any of the prior work that was done, right?
Correct.
Thank you. You also mentioned when we were talking about bias and bias complaints, you used the phrase formal bias complaint. And I want to make sure I understand what that means. Are you saying that there is a form that someone who is alleging bias, complaining about bias, has to get from the department, fill out, and then turn in?
No, just usually it's in writing. It's they submit us something in writing.
So for example, an email communication would be a formal bias complaint, yes?
Yes.
And would a phone call that is placed be a formal bias complaint?
Yes.
Your Honor, if I may have just 1 minute, I believe that I'm concluded.
Certainly.
Thank you, Judge. Thank you, Your Honor. I have no further questions.
Thank you. Ms. Weingarten, redirect if any.
Yes, Mr. Baker, you told us that it's unusual to open a case that's been closed. Is that right?
Yes.
If there's a new complaint on the same child involving the same perpetrator, does the case get reopened if there was a prior complaint, or is there a new case opened?
That would be a new report.
So
The new
give us a
complaint date.
situation, I'm sorry, go ahead.
Oh, sorry, a new report with a new complaint date.
So give us a situation where it would be appropriate to reopen a recently closed case.
If there was some error, or if there was additional information that was important to the case, then it would be a situation where it would be reopened.
Would it be because someone forgot to put something in the report in the first place?
Foundation,
Yes.
speculation.
Response to the objection.
Well, I'm asking him and his expertise about why one would ever reopen a case. I'm
Continue to-
having him clarify his testimony on cross.
Thank you. Any continued objection, Mr. Ashcraft?
Judge, no, I'll withdraw the objection.
All right, thank you. Continue.
So, Mr. Baker, can you tell us when a case is reopened, first of all, is it a rare event that a case is reopened?
Yes, and if I could just expand, if we're talking about currently we would do amendments. We typically don't do those anymore where they're reopened. It's just a change in features. So, but if we're talking about an older situation, it would be something that would have been reopened, but it's not typical.
How much older are we talking? So I think to focus our discussion, we should discuss from June of 2018, around that time period. Can you tell us whether the rules you've testified to today applied back then in June of 18?
So in June of 18, it probably would have been if there was a situation like that, we would have reopened.
Okay, so give us some reasons back in 2018 why a case would be reopened.
It could be some error, something that additional that wasn't addressed, additional information regarding this specific event.
Okay, so if it could be reopened and I assume the report could be added to, can the report also be, parts of it be stricken or erased?
That would be for social work context. That's the part I'm not definite. I know once the supervisor finalizes them, but if the whole case is reopened, do they all go back into pending status and then therefore can be modified? That is a possibility, but I can't speak to exact on that.
Okay, if it is if the social work contacts are reopened, is there ever a reason to erase or strike what had previously been written?
No. But
Now, you told us that law and policy require consideration of a non-custodial parent first, then a blood relative, and then a stranger. Is that right?
yeah, and you're, sorry, can I go back to the last question, Your Honor,
Sure.
to just expand on that?
Yes.
So if something was deemed irrelevant to the case, it might be a situation where something doesn't belong in a report.
So if something was deemed irrelevant in the social work context, what would happen?
If it was irrelevant to child abuse and neglect, and it was a determination made by management, then it would probably be stricken if it was completely unrelated to the case.
Okay. So when we're talking about the order in which you consider where to place a child, does a relative of a step parent constitute a blood relative?
Yes, I
Or
believe
let me
so.
say it this way. Let me rephrase my question. Is the relative of a step grandparent considered a blood relative?
Step grandparent.
A step grandparent.
I'm unsure. Sorry, I apologize.
Okay, that's all right. If you don't know the answer to
Without looking at
something,
policy to refresh.
say that again.
Without looking at policy to refresh, I can't say that I am certain about that.
Okay, that's fine. Are children sometimes removed before a family team meeting or a TDM can be held?
Yes. The
If
emergency
so, if that
situation.
happens, is the meeting held after removal?
Correct.
Now, you told us that if a parent only has supervised visitation rights, that it would be an error for CPS to place a child with that parent. Is that true?
Yeah, CPS, well, we work by our orders. So if we don't have an order, then everything's a voluntary agreement.
All right, so I want to give you a hypothetical question. If a child is removed from a home on June 24th of 2018, and the non-offending parent goes into family court and gets a court order from a circuit judge giving her full custody and presents that to CPS, would CPS honor that court order?
Yes.
Do parents sometimes get court orders on their own without involving CPS?
Yes.
The policies that Mr. Ashcraft read to you when he cross-examined you, it wasn't clear whether those policies were policies that are in effect now or were in effect in June of 2018. Have those policies that Mr. Ashcraft read to you changed since June of 2018?
It's kind of difficult to reflect on all the questioning and what policies have updated and what haven't. Policy is kind of fluid and it updates all the time. So it may not be all of policy, but certain parts of policy update. So it's kind of hard to say specifically which sections have updated since without looking at prior dates of policy and the current dates and comparing the two.
Okay. If there's a bias complaint and the decision has been made by management, such as yourself, as to the legitimacy of the bias complaint, did you testify that it would be noted in the final investigative report 154?
No, it would not.
Where would it be documented?
Well, like I said, if it was a formal complaint, sometimes we might talk to it depends on the nature, but we might talk to the person who made the complaint and give them a verbal, or it might be a written response.
So it might be documented or it might not be in writing?
Right, correct.
If a CPS worker writes something in a petition and the Attorney General disagrees with going forward on that allegation, whose decision is it ultimately?
Ultimately, it's our decision. to, our representation makes recommendations.
So what I'm asking is, if the Attorney General says, I don't think we should go forward on this allegation, and the worker who wrote the petition disagreed, who wins the fight?
Well, it would probably be escalated to the next line of management. We're often on calls together to talk about recommendations, from our council. And so sometimes they can be made at a higher level. They always have to have at least second line manager input to like something like a remove a termination language or something like that. Or if there's some vital part, obviously there probably are amendments that happen that are smaller amendments to the petition. So without specifics, it's hard to kind of.
Okay, so do I have this right, that the Attorney General is the lawyer for Child Protective Services?
Correct.
And the lawyer ultimately is the one who goes into the courtroom and makes the arguments about what should happen on a case, right?
Yes.
So if the Attorney General on the case disagrees with something that the worker wants to go forward on, isn't it true that the Attorney General has the final say as the lawyer on the case?
Yes, I mean, they do represent our interests, so they do ask for the input, but on the record, they would, it's consulted with us, if that makes sense, because they represent us. Or am I not answering it?
I'm sorry, I didn't hear the end of
Oh,
that.
sorry. Did I answer it? So, I mean, the Attorney General's office obviously makes recommendations to us. And if there's a disagreement, usually that would get escalated. And then we would decide if something should go forward or not on a petition. And then the AG represents us in court on that item. And
if
obviously if
CPS
there's, go ahead.
Okay, if the CPS worker wants to go forward on, say, a sexual assault allegation by a child, and the Attorney General says there is not enough evidence to go forward on this, does the Attorney General's opinion win?
Yes, usually, yes, it does. I mean, we take our advice from them. So if they don't think it's a point, then we would agree with that.
Okay. So there are times when a child makes allegations about abuse or neglect, and the Attorney General's office decides not to pursue those allegations in juvenile court. Is that fair to say?
Yeah, and consultation with us, the client.
All right. And if the Attorney General and the client can't agree, the Attorney General, being the lawyer on the case, has the final say. Is that fair to say?
Yeah. So if I could give an example for, I think that sometimes we have recommendations from the AG, but we could still pursue something if we wanted. If that makes sense, we would have to agree to, remove something, or obviously if there's not evidence to support it and they're making the recommendation to us, then yeah, we would agree.
Okay. One moment, please. When CPS decides whether to file a petition against a parent for abandonment of over 3 months, does CPS consider the parent's reasons for the abandonment?
Yes.
Are there times when CPS makes the decision not to pursue termination based on the parent's reasons?
Yeah, it's pretty speculative. It's hard without an example that to give a direct answer on a mandated petition question. It's kind of difficult to say without the specifics of the case.
Okay. Mr. Baker, do you know Judge Tracy Greene?
I know her in a professional capacity.
Do you know her as a former foster care worker?
Not in that role. I know of that, but I don't know. I didn't know her in that position.
So explain to us in what capacity do you know her?
Your Honor, am I ordered to testify about that, or is that something that can be?
Ms. Weingarten, do you have a general question that you're asking? And if she does, then we'll wait and see if there is an objection. Do you have a general question? Because I don't think the witness understands what your question is.
Well,
I'm
Judge,
trying to
it's-
establish whether Mr.
excuse-
Baker has a relationship with Judge Greene, either personally or professionally.
One moment, please. Mr. Ashcraft, you're trying to make an objection.
Judge, I didn't understand where the question was going as well and what Mr. Baker was about to say. But if we're getting into a fact or case-specific situation here, obviously that's prohibited.
Ms. Weingarten, say again why it is that, where you were trying to go with this.
Well, I want to know whether he has a relationship with her personally or professionally, and it could potentially go to his credibility or his bias. I don't know.
Mr. Ashcraft, do you have an objection at this point?
I do not at this point, Judge.
All right. So I'm going to allow you to answer the question, Mr. Baker. There might be a follow-up question. There might be an objection. So let's just take it slowly to see if there is an objection. Go ahead, Ms. Weingarten. Ask that question again, please.
Mr. Baker, could you explain to us what type of relationship you have with Judge Greene?
I met Judge Greene through my role as district manager. I think we had one meeting and maybe two phone calls.
About the case for which we're all here, or about something different?
Judge, we're now going up across the line. If it's a question specifically related to the case, then obviously this cannot be addressed in any respect, and it is prohibited. If it's,
Ms. Wein-
Judge,
Thank you.
I disagree. I think if it is related to this case, then that does show that he could potentially be biased, and a witness's bias is always an issue.
All right, thank you. One moment. Council, let's have a sidebar on this question, and we'll go to another room to talk about that. Mr. Baker, you're still under oath. We have to discuss something before we come back to you.
Okay, thank you.
All right, we are back in the main room. Ms. Weingarten, would you please re-ask the question that we discussed during the sidebar?
Yes, Mr. Baker, do you and Judge Greene have a personal or professional relationship or both?
No, neither.
All right, thank
Thank
you.
you. I have no other questions.
Any recross, Mr. Ashcraft?
He's muted.
Thank you very much, Judge. I do have a few questions.
All right,
Mr. Baker, the Attorney General does not make the decision for CPS. CPS makes the decision in terms of whether to go forward with allegations and a complaint, right?
Correct, but the AG does make recommendations for us when we're in court.
Right, thank you. Now, you told Ms. Weingarten about amendments. Do I understand correctly, Mr. Baker, that a CPS investigative report, Form 154, that has been finalized in the system and the case closed, can then be reopened later on for purposes exclusively to amend the already finalized report?
Well, to do additional work. Like I said, I wouldn't say over an extended amount of time. In the past, like I said, now we're not doing that, but we're doing, when we talk about amendments, but if we're talking about 2018, we would reopen if immediately we caught something that needed additional work.
Okay, but you said you're saying now additional work. My question was a little bit different. My question was it would not be reopened by the department for purposes of simply amending, modifying, or revising that previously finalized report, correct?
So if there's additional information that didn't get into that report, then it could be modified. Maybe I'm a little bit confused by the modified amendment part, but if we're reopening it to add information, that would be a modification.
And I think you're cutting out there, Mr. Baker.
Oh, sorry. No, what I was saying though, if we're reopening to do additional work and to modify something, then that could take place.
Well, you keep saying additional work. Does that mean that if something has developed in the case that has already been finalized and closed, that you would reopen and then do the additional work which might include amending the 154 to include additional information?
Correct.
Okay, but it's not that you can decide, when I say you, of course, I'm talking about CPS, can decide later after the matter is finalized and closed that maybe we should have included some additional information in the 154. We're going to go ahead and reopen that to revise, modify, or amend the 154, correct?
The staff and supervisors have to go get my approval to be able to reopen. So they can't do the functionality of reopening a case.
Right, but that doesn't answer my question, Mr. Baker. I didn't ask specifically about levels of people that could take action. I specifically said CPS could not.
Go in and modify it on their own? No.
Right. And the reason is because it was finalized and closed in the system, correct?
Reference to
The 154.
okay, just a general 154. Yes.
Yes.
Finalized and closed.
The CPS investigative report on the 154 form. That's what I'm talking about.
Correct.
Thank you. And so CPS cannot decide after the final is finalized and closed, sometime later on, to reopen for purposes of going in and striking something from the CPS investigative report?
No, they can't decide that.
I didn't hear what you said.
No, they can't decide that.
Okay. They can't decide to go in and alter it in any way, correct?
Right. Not unless it's been given approval to be reopened.
But if it's given approval to be reopened, that's because of a development in the case involving the actual case. And additional work has to be done, correct?
Correct.
Not just because they want to go back in and add or subtract something to the previously finalized and closed form. Yes?
Yes.
Thank you. I have no further questions. Thank you, Your Honor.
Right, thank you. May this witness be excused.
Yes,
All right, thank you. Mr. Ashcraft, any objection to that?
No objection, Your Honor. Thank you.
All right, thank you, Mr. Baker. We will excuse you, so you may leave the meeting at this time. And we will find out if your next witness is available, but we'll take a 10-minute break before we get into the next witness. I don't see anyone in the waiting room at this time, Ms. Weingarten.
okay, we'll make sure she is.
All right, thank you.
Thank you, Your Honor.
You're welcome. Thank you.
Thank you, Judge.
You're welcome.
Could you kindly put us into the breakout room temporarily?
Certainly, I will.
Thank you.
I believe everyone is back at this time. And I see that your witness Ferguson is in the waiting room, so I will let her in at this time. Are we ready to proceed with this witness, Ms. Weingarten and Mr. Ashcraft?
Yes.
Yes, Judge.
Thank you. Good afternoon, Ms. Ferguson, I believe it is. Thank you for unmuting. My name is Betty Widgeon. I am the appointed master in this matter, and we are going to start with me swearing you in. First, I'll give you the general oath, and then I'll ask you about the two orders that I've signed with respect to this hearing. One has to do with general witness protocol, and the other one has to do with the sequestration order. All right, raise your right. Thank you. Raise your right hand, please. Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth? So help you.
I do.
Thank you. And what is your name?
Bobby, Bobbijo, Ferguson, Ferguson.
All right, thank you. First, I'll talk about the general witness protocol. Witnesses shall certify that they are alone in the room where they testify or identify all individuals present during the examination. Are you alone in the room at this time?
Yes, I am.
Thank you. No witness shall access or review any documents or other materials beyond the relevant trial exhibits, pleadings, or transcripts or police reports during their testimony until the trial is over. No witness shall have a document within reach or sight. If a witness needs to refer to a document, she may do so only if invited to do so by counsel or approved by the master. Do you understand that?
Yes.
All right. Witnesses shall certify under oath that no one has given them information by any means to assist in testifying that counsel and the master cannot observe. Do you so certify?
Yes.
Witnesses shall not have access to cell phones, laptops, smartwatches, or similar devices in the room during their examination other than the device they will use for their testimony. Do you understand that?
Yes.
So if you have a cell phone right now there with you, you need to put it out of reach. All right. Thank you. Thank you. Now I'm going on to the sequestration order. This order and the sequestration will remain in effect until the witnesses are released from it by the master or until the proceeding before the master concludes. To be clear, this means that the order remains in effect even after the witness testifies, unless the witness is released by the master. Sequestration includes a prohibition of on any witness, except while testifying via Zoom during the proceedings, from doing any of the following: from discussing your testimony in any format or by any means with another witness, from viewing the proceedings on any device, from listening to the proceedings on any device, or accessing or viewing any information about the proceedings via any social media or news outlets. Do you understand that order?
Yes.
Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. A failure to serve the order by any party or a violation of the order by a witness is grounds to exclude a witness or to exclude testimony given by that witness prior to discovery of the failure or the violation. Do you have any questions regarding that?
No.
All right, thank you. Counsel, I believe we're ready then to proceed with the direct examination of this witness, Ms. Weingarten.
Okay. Good afternoon, Ms. Ferguson.
Good afternoon.
My name is Laura Weingarten. I'm the person who subpoenaed you. Okay. Can you tell us what your job title is?
I am a state administrative manager with the Michigan Department of Health and Human Services.
How long have you been the manager?
I have been a manager for of the particular units I've been serving since March of 2019.
And are you in charge of the CPS expunction and redaction unit?
Yes, I am.
What does the word expunction mean?
Expunction is, and for our purposes within our unit, it is the review of placements on central registry. It is the removal of the name from the central registry.
And what does the redaction unit do?
Our redaction unit covers a statewide, so I'll count 83 counties within our department. So just the Department of Health and Human Services on the Children's Services side. If there's a request for Children's Protective Services, investigative reports, ongoing reports, or closing reports affiliated with an investigation or ongoing case, those requests come to our unit in order to redact and provide to eligible requesters.
Is there a policy about what should be redacted?
Yes, there is.
And is there a name or a number given to that policy?
Yes, it's the Services Requirements Manual, SRM 131, and that contains all of their policy requirements for redactions.
Before today, had you sent that to me?
I believe it was provided to you.
Okay. Your Honor, the disciplinary counsel wants to mark that exhibit as exhibit 40 and move to admit it. Mr. Ashcraft has a copy.
Judge, just so we're clear, this is something that Ms. Weingarten and I spoke about earlier today, as a matter of fact, and that document is what's being marked as exhibit number 39, actually.
I didn't realize that was the same document we're talking about. Okay.
All right, so it's exhibit number 39.
Yes.
All right,
Yes.
that is admitted. Did we discuss this earlier and call it 39A or something like that? No.
No, Judge, that was actually 9A.
9A. All right, thank you. Exhibit 39 is admitted. You may continue. Thank you.
Thank you.
Ms. Ferguson, when a person requests a copy of a Child Protective Services investigation report, is it common that what they receive back has redactions in it?
That depends on the requester's role within that investigation or that request.
So when might someone receive a request that has no redactions whatsoever?
Unless we receive a court order signed by a judge who authorizes unredacted material.
So was it fair to say most of the time you do some redactions?
Yes.
What information is redacted pursuant to policy?
That actually is defined depending on the requester's role within the request for the documents and within the role within the investigation and ongoing case.
If the requestor is not a parent or guardian, but is named in the report, let's assume those facts for the next set of questions that I ask you. Can you tell us what typically is redacted under those circumstances?
Can I ask if that person is an alleged perpetrator or just a person interviewed?
A person interviewed.
A person interviewed. Okay. I'm sorry. Can you repeat the question?
So the question is, what things are typically redacted from the report before that person gets a copy?
If in general they are not named an alleged perpetrator or they have a child in that report, if it's just somebody who we've interviewed within our investigation, they cannot receive that report.
Okay. What if someone is named as an alleged perpetrator? What information is redacted from the report?
That information, if that alleged perpetrator is not a parent of the child victim, then the information that would be redacted is our reporting source, or other known as referral source. If it is not their child or their own mental health records, if it is not their child or their own substance abuse treatment records, that also goes with HIV and AIDS information. Ongoing and open law enforcement investigations would be redacted, and information contained directly from Lean would also
What
be
is Lean?
redacted. Law Enforcement Information Network.
So is that criminal histories?
Yes.
What else?
Off the top of my head, I believe those are the redactions that would be contained. Other than if they're not a perpetrator of child abuse in the report, other child protective services history that may not be associated with them, or another named victim in the case or perpetrator in the case.
Would social security numbers be redacted?
Yes.
Would educational records be redacted?
If it is not, if they're not the parent or they're not their own record, yes.
Now, all the things that you've mentioned that should be redacted, does that appear in the SRM 131 that you talked about earlier?
There are provisions and the policy is set forth, yes.
Does the redactor have any discretion?
No.
They must follow the written policy?
Yes. If there's questions, then there's a protocol to seek the answers prior to the completion of that record.
And are you the supervisor of all the redactors?
Yes, I am.
Do you monitor their work to make sure they're following policy?
Yes, I do.
How do you do that?
I take it, there's a random sample that's pulled for each one of the redactors, and that's completed on a monthly basis.
Do you ever override something a redactor redacted or failed to redact?
Yes.
Does that ever happen after you've released a report?
Yes.
What would be the procedure if you have already released a report and then you audited it and learned that there were some errors? What would be the procedure you would follow?
If there are errors, typically what I do is review the record, and then I also review the record with whoever redacted it, and we discuss the errors, and if they're substantial or numerous errors, I will provide the requester a new copy of the redaction, the correct version of the redaction.
And do you send a cover letter explaining what you've done?
Typically, yes. Just
What does
highlighting that there was errors.
Does the cover letter say anything else other than that there were errors?
No.
I just have one question. Does the cover letter, is that an email during these days, or is it an actual posted letter?
You know, typically, what I do is I complete the packet and then I send it to our counties, the person that's designated within the counties, and the counties typically send that correspondence through United States Postal Service, or depending on who the requester is, we do have the authority in certain circumstances to email that.
Thank you.
Do you draft the letter yourself?
Yes.
In the CPS investigative reports, there is always an area called case conference supervision or case conference documentation. Are you familiar with those terms?
Yes.
Can you tell us what is written about under those titles?
Typically, that's what you're going to see within our social work contact section. And that is typically a meeting between the worker and supervision. And they're consulting and discussing the investigation or ongoing case.
Is anything they may discuss redacted according to policy?
Yes, it has potential.
Are you familiar with a form DHS 269?
Yes,
What is that?
that is the lien request, so law enforcement information network request.
And is that information listed under that paragraph in the report redacted pursuant to policy?
There's potential.
Okay, when you say there's potential, what exactly do you mean by that?
It depends on the requester and what information is contained within that, and if it has been verified by an external public site.
So if someone is seeking a report and it isn't about them and it's not about their own criminal history, would that information typically be redacted?
I'm going to have to say it depends. It depends on whether or not that information was verified through another public source.
Okay. There's also an area within the investigative reports that's called CPS case history search. Are you familiar with that?
Yes.
What does that mean?
That is individuals that are affiliated with the investigation as alleged perpetrators or victims. That is containing all of their prior Child Protective Services history with the department.
Is that information confidential?
It depends on the requester's role.
Okay, and could it be redacted from some reports depending on who the requester is?
Yes.
Is there a section in the CPS investigative report called disposition/narrative?
Yes.
Are you familiar with what is written in that area?
Yes, I am.
Tell us in summary what is written in that area.
That area is to contain a summation that has occurred during the investigation, the factual basis for the findings. So it is essentially the findings and what the department's actions are in the case.
And is that area sometimes redacted depending on who the requester is?
Yes.
So basically what you're telling us is based on the requester's eligibility, the report may or may not contain the redactions we've talked about. Is that fair to say?
That is fair to say, yes.
Okay. If a person close to an abused child reports to CPS that she put makeup on an injury she knew was inflicted by the child's father, would that information be redacted from the report?
Jackson.
One moment, please. First of all, I want to find out whether Ms. Jorgensen was able to hear the whole question because it was breaking up for me. Did you hear that, Ms. Jorgensen?
I believe I did.
All right. And there is an objection from Mr. Ashcraft. What is that objection?
Judge, this violates the prohibition on getting fact-specific and case-specific.
Response. Ms.
Judge, I'm
Weingarten.
asking a hypothetical question that does not involve the people involved in this case. It's hypothetical.
Continued objection, Mr. Ashcraft.
Yes, Judge, it is specific enough, and we've addressed this earlier in this proceeding with different witnesses about coming too close to the line, allowing inferences and specific intimation otherwise. So I respectfully object that this crosses the line into the prohibited area.
Anything further, Ms. Weingarten?
Judge, I was allowed to ask Ms. Apple a hypothetical question, and it's really not that different than what I'm asking this witness.
Let me hear your question again, and Ms. Ferguson, don't answer the question yet. Let me hear what it is.
Okay, if a person close to an abused child reports to CPS that she put makeup on an injury she knew was inflicted by the child's father, would that information be redacted from the report?
All right, thank you. Mr. Ashcraft, do you have an objection to that wording?
Nothing further, Your Honor.
All right, I'm going to allow you to ask that question, Ms. Weingarten. Continue.
Ms. Ferguson, did you hear my question? Or do you need
Yes,
me
I
to
did.
repeat it?
No, I've heard your question. Thank you. For clarification, is this the reporting source or is this just in the general interviews of a grandparent that we typically interview?
Okay,
Same,
so
same
we
objection,
can't
Your
talk
Honor.
about
All right,
cases.
one moment. So Ms. Weingarten is saying that she cannot talk about more specifics, basically, is what she's saying.
But
And,
wait, I can say
and-
that. Assume
okay.
for the purposes of this question that it is not a reporting source that made that allegation.
All right, one moment before you answer. Mr. Ashcraft, you had an objection. Do you have an objection to the way it has been specified just now?
I do, because now by rephrasing the question in the way that it's just been rephrased by disciplinary counsel, the question that was asked by the witness has been answered.
Ms. Weingarten, further response, if any?
Judge, could I ask the question both ways? If the person was a reporting source, or if the person was not a reporting source, and get the answers to both of those questions?
All right, and Mr. Ashcraft, are you having an objection to it being asked in that particular way?
I have the same objection, Your Honor. I think it's too close to the line and specifically over the line as to your original order.
All right, I'm going to allow the question to be asked that way, and then Ms. Weingarten, have you move on.
Okay.
Thank
Ms.
you,
Ferguson,
Judge.
I'm going to ask you the same question involving two different people. So the first question is, if a person who was not the reporting source, but close to an abused child, reports to CPS that she put makeup on an injury she knew was inflicted by the child's father, would that information be redacted from the report?
No,
Okay, now I'm going to ask you the same question. If the person was a reporting person and was close to the child who reports to CPS that she put makeup on an injury that she knew was inflicted upon the child by the father, would that information be redacted from the report?
if it was based upon the initial reporting source information that came into the department, it would be. If it's not part of the initial reporting and it's a follow-up required interview, it would not.
It would not be what, redacted?
Redacted. It would not be redacted.
Okay, so what you're saying is if it came from the reporting source and there was no follow-up investigation, it would be redacted. Is that
Yes.
true?
Yes.
But if it came from the reporting source and then that person was interviewed again, then the information provided would not be redacted. Is that what I heard you say?
If they were required to follow up and have a interview conducted, then it would not be. Correct.
Are things said in the social work contacts between people who provide the worker who writes the report with information, are things said, factual things, redacted?
No.
Is there anything else you can tell us about the redaction policy that you think would be helpful to us?
No.
Thank you. I have nothing else, Your Honor.
Thank you. Mr. Ashcraft, any cross-examination for this witness?
I do. Thank you, Your Honor.
Yes.
Good afternoon, Ms. Ferguson.
Afternoon.
As the state administrative manager, first of all, have you spoken with Mr. Baker today?
No, I have not.
Thank you. As state administrative manager for the State of Michigan Department of Health and Human Services, you are familiar with all of the policies, guidelines, and the manuals for CPS, correct?
I know how to navigate them, and I'm very familiar with the area that I service.
And that's specifically the redaction area.
Correct.
Thank you.
Or-
And we've already identified SRM 131 as being that manual, for want of a better word, that addresses those areas, correct?
Yes.
And SRM 131, that follows the state law with regard to Michigan child protection laws, correct?
Yes.
Upholding confidentiality is taken very seriously at DHHS, correct?
Yes.
In fact, anyone who violates this protection can be guilty of a misdemeanor and can be civilly liable for damages, correct?
Yes.
The spouse of someone who is a suspected perpetrator of abuse or neglect is not authorized to receive access to CPS case information, including reports, correct?
Could you repeat the question, please?
Yes. The spouse of someone who is a suspected perpetrator of abuse or neglect is not authorized to receive access to CPS case information, including reports, correct?
Is that spouse also a named perpetrator?
The spouse of the suspected perpetrator.
That depends, is that spouse a named alleged perpetrator or a parent of the child that's a victim in the case?
Okay, so explain that, please.
If there is,
I'm sorry, you were cutting out there. I'm sorry, you froze for a moment.
parents of children who are alleged victims are entitled to receive reports regarding their children.
Okay. A spouse is not listed as one of the individuals authorized to receive CPS case information, right?
And for clarity, is that spouse a parent of a victim?
Correct.
The parent of a child victim is entitled by the child protection law and SRM 131 to receive certain areas within that investigation.
Thank you. A television news reporter is not listed as an authorized recipient of CPS case information, correct?
Correct.
So if a television reporter has a copy of a CPS report for a case he's investigating, that would be proof of a violation of the confidentiality laws and the policy, wouldn't it?
If that copy of that record came from the department.
That's correct.
If it was not released by the department director, then it is a violation. If we directly gave it to that individual.
Okay. And even if a person is listed as eligible to receive CPS case information under the confidentiality policy, any report must be redacted before it's sent to a qualified recipient, right?
It's reviewed for redactions.
And the confidentiality law and DHHS policy do not allow release of a suspected perpetrator's CPS case information to a parent of an abused or neglected child before redactions to safeguard the suspected perpetrator's confidentiality, correct?
Could you explain that question?
Sure. The confidentiality rules and the policies, specifically SRM 131, do not allow release of a suspected perpetrator's case information to a parent of an abused or neglected child before redactions to safeguard the suspected perpetrator's confidentiality, correct?
If we receive a request, those must be reviewed for appropriate redaction.
And then they would be, the information is confidential, like the identity of a suspected perpetrator, would be redacted, correct?
Can I ask clarity? So the identity of the alleged perpetrator and who is the requester?
The requester is to a parent of an abused or neglected child.
If that parent has their child as a victim, that parent is entitled to that record.
Even if it is a suspected perpetrator?
If there are allegations that involve their child, the redactions are completed through the provisions of SRM 131, which would give that parent, if their child is named a victim, then that would be redacted according to those provisions within RS 131.
Thank you. If CPS lawfully provides a parent with CPS case information about a suspected perpetrator of abuse or neglect, but the parent shares that information with the media, for example, that would be subject to criminal and civil liability, wouldn't it?
That is some
Objection. Judge, you're muted.
What's the objection?
The objection is a lack of foundation. It's a legal question, not something that this witness can answer.
Response, Mr. Ashcraft.
Judge, I'm entitled to explore the basis of her knowledge, and she specifically testified that SRM 131 is connected to Michigan's law, specifically the Michigan Child Protection laws. So I'm certainly entitled to ask that question.
Anything further, Ms. Weingarten?
I think it calls for a legal conclusion, and there's been no evidence that she's a lawyer.
Do you want to back up and get some foundation, Mr. Ashcraft? I would allow that.
Sure, thank you, Judge. Ms. Ferguson, you are familiar with the Michigan Child Protection laws in Michigan.
Yes, I am.
And as a matter of fact, there are times when you specifically send out information in response to inquiries to CPS for reports, records, etc., where you actually cite criminal and civil liability rules and statutes, do you not?
We provide the legal citation, yes.
And that's because you understand that those legal citations support the CPS policy contained in SRM 131, correct?
I am aware of the citation.
And you actually cite them yourself. In other words, you provide specific citations with a warning when you release information, do you not?
Yes.
Thank you. Judge, I believe I've laid the foundation for this question.
Continuing objection, if any, Ms. Weingarten?
Yes, the witness said she knows the citation. She did not say she knows what the content of the citation is or the legal ramifications.
Mr. Ashcraft, do you have a couple of additional questions you can ask for the background, please?
Certainly, Judge. Ms. Ferguson, you would not cite to the law, Michigan compiled laws, statutes, and the like, and specifically the Michigan Child Protection laws, without having some familiarity with them, correct?
We cite our policies, and if the law is included, we're aware of our policies.
I'm sorry, you're aware of your policies?
Guess I need further clarification of the question.
Sure. When you send out information, Ms. Ferguson, in response to an inquiry or a request for information to be released by CPS, you cite the law, specifically the Michigan Child Protection laws, and you also advise the recipient of the information that you're sending out that anyone who violates the protection of the law is guilty of a misdemeanor and is civilly liable for damages, correct?
We make that citation. Yes, we do.
Thank you. Judge, may I proceed?
Is there any continuing objection, Ms. Weingarten?
Well, again, Ms. Ferguson said she makes the citation, but that doesn't mean that she knows what the citation means or what the legal ramifications are.
All right. Mr. Ashcraft, you may ask your question at this point.
Thank you very much, Judge. Ms. Ferguson, if CPS lawfully provides a parent with CPS case information about a suspected perpetrator of abuse or neglect, but the parent shares that information with the media, that would be subject to criminal and civil liability, correct?
That is a matter for the prosecuting attorney in that area. That is nothing that I can attest to.
But your understanding is that doing so would violate the citations to the Michigan law, and specifically the Michigan Child Welfare Act, that doing so would subject that person to both civil and criminal penalties, right?
I believe that is what you're citing out of the child protection law.
Thank you. As a matter of fact, you specifically state in your enclosure letters over your name, where you send out information protected by CPS that has been redacted by your department, over your name, you send out an enclosure letter or a transmittal letter or a transmittal email, as it might be in today's world, where you say, quote, the confidentiality of information in this document is protected by the Michigan Child Protection Law. Anyone who violates this protection is guilty of a misdemeanor and is civilly liable for damages, paren 1975 PA 238 as amended, MCL 722.621 at sec, close paren. Correct?
That is a disclosure that I believe you're citing directly out of what is contained on our letters and which is contained within our SRM 131. That
And
is a
that letter-
disclosure.
I'm sorry, I spoke over you.
No, that it's our disclosure.
And in fact, it's your disclosure because you send it out sometimes over your own name, correct?
Yes.
Thank you. And who makes redactions to the CPS reports?
Excuse me?
Who makes the redactions to CPS reports before they're released?
The CPS investigations ongoing, and can you be specific? CPS reports, there's many different types of reports and not all are completed.
So for example, let's talk specifically about the investigative report that we've identified earlier through Mr. Baker as Form 154. You're familiar with that document?
It would be an investigative report?
Yes,
Yes.
thank you. And by the way, are you making reference to anything while you're testifying today? Looking
No,
at
Your
anything?
Honor. I have myself and a pen.
Thank you very much. And so let's talk about when a request comes in from someone who's authorized to receive a CPS investigative report. It has to be redacted. And before it goes out to that person, it is redacted. My question is specifically, who makes those redactions?
It depends on what time period are you referencing the redactions were made. And
Let's say up until June of 2018.
that would be the local county.
The local county?
Yes.
Okay. And after June of 2018.
What period of time?
Through the present date.
The local county and the redaction unit or the redaction unit. It depends on the point in time, as well as how the request came in, et cetera.
And do redactions have to be made a certain way?
All redactions are based upon the type of requester.
And you testified to that earlier. Let me ask a better question. Can they be made manually or electronically?
Yes,
They can be made both ways.
either or.
So someone can take a Sharpie, if I may use that word, and black out certain things in a report and redact in that fashion.
Yes,
And they can also do it by way of a computer function where a document is made into a PDF and they're able to then block and black out certain areas to redact, correct?
yes,
So if a CPS report has been redacted, there would be visible black marks on the redacted sections, correct?
if there were any redactions to the request.
So simply deleting information from a CPS report is not a proper redaction, correct?
That is something that our unit does not do.
And simply omitting something from a CPS report, that's not a proper redaction, correct?
Omitting from the CPS report, like
Yes.
intention, can you clarify?
Yes, so if a request comes in and the document is printed off, you wouldn't simply omit something that is being redacted by not including it in the documents printed off, for example.
Are we referencing after a report has been approved and the information input into the report?
Yes,
Then it would be, if there's information to be redacted, it would be redacted.
and when we say redacted, we say it's being blacked out so that people can see, whoever the recipient is, can see what has been redacted.
Yes,
Thank you. Now, in the event a request comes in from an authorized inquirer for a copy of a CPS investigative report, and the report is requested on an emergency basis or an expedited basis, and the time that ordinarily takes for your redaction department to do its work to redact is not afforded, does CPS send out those reports without redaction?
No,
There's always redaction, regardless of whether or not a 14-day time period or window for the redaction unit to do its work occurs, right?
if there are redactions required, all the reports must be redacted.
Without exception, meaning in terms of whether it's requested on an emergency basis or an expedited basis, correct?
Unless via court order requiring unredacted copies.
Thank you. Despite the law and CPS's or DHHS's policy, mistakes are sometimes made, correct?
Yes,
And the mistakes are uncovered during audits, is that right?
yes.
And who is it that determines whether redactions have been performed correctly in a given case?
The redaction tech is the one who completes the redactions. So they are making the determination. And if there's questions regarding that redaction, they present them to me.
But if mistakes are uncovered, you indicated they're uncovered during audits, correct?
Yes,
All right, and then who is it then that makes the decision as to whether or not those redactions were accurate?
I do. And if there's questions to the redaction that I cannot attest to, then I seek, I consult for guidance on those.
When you, I'm sorry, did you say consultants?
I consult for guidance.
Or you consult with guidance? Is there a particular person within the hierarchy of DHHS that you do that with?
Yes, our training is all provided through our Children's Services Legal, as well as Office of Field Advocate.
Thank you. Once discovered, the mistakes are corrected, right?
Correct.
And are when that occurs, then the corrections are made by you.
In some of the cases, yes, if it's substantive and I'm having to resend it out, yes.
So what about if they have already supplied, if you have already supplied CPS reports that contain CPS case information to a qualified requester before erroneous redactions have been corrected? You still make the corrections, yes?
If over redaction has occurred, yes.
And then do you send out then an updated version of the corrected investigative report?
I'm sorry, Your Honor, I could not hear the end of the question.
All right. Please re-ask that question.
Yes, Judge, thank you. At that point, Ms. Ferguson, do you then make the corrections and then send out a corrected version to that qualified requester?
If there's over redaction and it impacts their ability to receive the correct information, yes.
Now, is there a policy where CPS examines closed files to see if redactions in reports previously released were accurate?
Are you talking as a department or as a whole, or referring to the redaction unit? I can only attest to what the redaction unit does.
Well, certainly. Well, then tell me about the department that you head up.
The redaction unit, we provide some of the redactions throughout the state.
And I'm sorry, you cut out at the end. You provide some of the redactions for what?
That are completed throughout the state.
Throughout the state. Right. My question was specific as to whether or not your department goes out and looks into closed files to see if CPS investigative reports that had been released to qualified recipients had been properly redacted.
I can't answer that. That's a local county process.
You don't reopen files for the specific purpose of revising, amending, or correcting anything in a CPS investigative report, correct?
I can't answer that question. I don't understand what you're talking about, open files.
A file, you understand that a investigative report can be finalized and filed in the system, and then the file can be closed, right? Or is that not something that your department deals with?
I'm just trying to seek clarification of which role you're referencing and which file you're referencing. I don't have access to hard case files, so I only can go through an electronic record. And our redaction unit doesn't open files or open cases.
So your unit then only receives information provided by some other group or department within CPS indicating that an authorized requester has asked for a copy of an investigative report and you need to do your redaction work?
We have an electronic system that houses our case files within the department. And if the reports are located within that electronic case system, then we can provide the redactions for the requester as requested. But if there's files within the hard files within the local county office, I can't attest to what their process is within the county offices.
Okay. What is a form DHS 1910?
That's something that the redaction unit would be familiar with knowing a number. Can you reference the name of that form for me, please?
Actually, I can't. I just know the number. You're not familiar with DHS 1910?
I'm familiar with, we have a number of reports.
Okay. So you are the head of the redaction unit. Do you yourself actually get into the process of handling redactions, or is it people within your group that do that?
I believe I stated that when errors are found, I do process those amended requests, and in certain circumstances, I may actually process a request.
And how are those errors or suspected errors brought to your attention?
Random review or client complaint. It could come in any different variation.
When you say random review, how do you go about doing that?
I randomly take a random review of the work that's completed by the technician. And of course, that's completed work. And then I process that, or if there's questions on something and they bring it to me, and then I will review it with them.
So the technician has the discretion to do the redaction as he or she sees fit, and it wouldn't rise to your attention unless there was some sort of a complaint about an error or through your random sampling process of checking.
No.
Is that correct?
No.
That's not correct?
No.
How else do things get to you personally where you serve as the redactor?
The staff will bring it if they question whether or not it's a questionable redaction, then they will bring it to me. Otherwise, we are trained on a quarterly basis regarding our redactions to provide consistency and accuracy.
And your technicians do that on their own?
Yes.
Yes. And the only way that you would get involved personally would be if it's through the random sampling process, or a technician comes to you, or you're dealing with a complaint. Is that right?
Yes,
I'm sorry, did you say yes?
yes,
Thank you. And are you ever personally involved in processing the request for the release of a CPS report?
I may if there's a conflict.
What does that mean?
If there's someone within the unit that has a conflict on one of the requests, so they have a relation to the case.
When you say a relation, you're talking about some sort of personal familiarity or family connection?
Correct, it's a conflict of interest.
Otherwise, you do not?
I may, depending on the requester and the timing of the request, if we have a significant volume.
You have a significant what, please?
No, it depends on the volume and the ability to provide those timely and accurately as outlined by the law.
Understood. You also said it depends upon the specific requester. What does that mean?
If there's a conflict of interest.
So that's just connected to the conflict of interest. It's not based upon a specific class or group of requesters.
Absolutely not.
Okay, thank you. Your Honor, may I have just a 2-minute break here?
Yes, you just want to have a break, or do you want to be sent to the breakout room?
Yeah, I'd like a break to simply review my notes to make sure that I've completed my examination. And as part of that, I would like to be placed into a breakout room, please.
All right. One moment. And it's 4:25. Let's return back at 4:30. So Ms. Ferguson, if you want to mute yourself or shut off your camera for 5 minutes, feel free to do that.
Thank you.
Thank you. It looks as if we're all back. Mr. Ashcraft, please continue.
Thank you, Judge. I have no further questions.
Thank you. Any questions on redirect, Ms. Weingarten?
No, thank you.
All right, may this witness be excused.
Yes.
Thank you, Ms. Ferguson. You are excused, so you may leave the meeting. Thank you.
Thank you.
Are there any additional witnesses for the disciplinary council today?
No.
Thank you. All right, so at this time, we will end the hearing today. Council and I will remain in the court reporter and Judge Greene, and we'll see if there are any matters that we need to discuss off of the live streaming. All right, thank you very much. Appreciate that. Ms. Drysdale Crown, thank you for being here today. All right. All right, at this time, I'm going to stop the live